So this week, we are going to be discussing your law of insurance. Does anyone know anything about insurance? Maybe in brief? Anyone want to explain to us what they know about insurance? Who are the parties involved? What performance is required from the parties? Can anyone give an example? Miriam. Pooja, anything?
No, ma'am. I've only done calculations for insurance, never the theory.
Do you know what is insurance though, in short?
Yes, somewhat.
Okay, please explain to us.
So it's basically when you take a policy, according to my understanding, take a
Okay.
policy to insure or to cover any damages that occur to any of your assets, as such, maybe your vehicle or a piece of land or building. Yeah.
Excellent. Thank you so much, Pooja. Pooja is a very important word, cover. Okay, so that's what we're going to talk about here. Insurance covers you from any loss or damage that you may suffer in the future, any uncertain events that may occur. So the parties involved here are your insured, being the person that's taking out the insurance policy, person who wants to cover the house from any damage from fire, from floods, okay? A person who covers their phone from theft, okay? That's the insured person. And then we have the insurer, your insurance companies. For example, your Discovery Insure, your One Life Insure, okay? So you have the insurer and the insured. The insurer undertakes to indemnify the insured for any loss that may happen to any item that is discussed in the policy, okay? She also used the word policy, okay, between the two. That policy is the contracts that we are going to focus on, all right? So this blank screen is a video that you guys can look at. So in your slides where you have your voice, there's a video about insurance and what insurance is all about. So in this session, part one, we're going to speak about the relevance of insurance. You're going to talk about the economic function of insurance. We're going to define what insurance is. We're going to talk about insurance law and insurance business. We're further going to talk about your South African insurance law. We're going to discuss the three branches of South African insurance. Then we're going to move on and look at the different types of insurance. Remember, there are 4 parts to the law of insurance sessions that you guys have or lectures that are uploaded for you. So if we don't finish, please have a look or listen to the recordings. Recordings are inclusive of the slides, so it's an explanation of what the slides cover. So why is insurance relevant? Okay, so when loss occurs and in order to help reduce the risk a business may suffer to its premises, for example, or if it may lose equipment and stock, it takes out insurance. So you'd find that many businesses will take out insurance, even persons or natural persons on their own will individually take out insurance to cover them from any loss. So in such an event, a payment from the insurance company, that's your insurer, may enable a business to survive, okay? So after this loss, you get a payout and you are then able to survive or recoup what you have lost during maybe that particular event or that peril that caused the harm. So one's business may depend on a skill of a person who may be difficult to replace. So you'd find that in a business, we have a person who has a skill that the business is highly dependent on. We can actually cover that person's skill under an insurance policy. So if that person dies, then the business is able to get cover from that person dying, or is able to be paid by the insurance company for that particular person dying, and it makes up for their life. Obviously, it won't make up for the entire life, but it does help the business to survive in a way. So if a business partner dies, interest may be brought by the remaining members, and insurance is a way for people and businesses to protect themselves against the risk of loss. So the concept of insurance, with the concept of insurance comes risk, and risk is very central, or it's a very central term to insurance. Risk is the possibility of a peril or damage that may occur and cause harm to the person or their property. Okay, so harm may be caused by perils such as your natural disasters or your unemployment. Some people cover themselves for unemployment. For example, you might get retrenched one day, so you are covered for that. So the insurance company will actually pay you out on the day that, or once you make a claim with them saying that you have now been retrenched from work and you are covered for unemployment. Okay, the harm one suffers can be patrimonial or non-patrimonial. Now, what patrimonial means is that where you have suffered a loss and you had to now take money out of your pocket to pay for that loss. Okay, that's patrimonial loss. And your non-patrimonial loss is something that you cannot measure in economic terms, such as your pain and suffering. And an example is given here on your notes. For example, a salesperson who works on commission is injured in a motor vehicle accident. What they will claim under patrimonial loss will be their medical expenses, because they will go and see a doctor and they will have to pay money out of their own pockets to get that medical assistance. The loss of income, okay? They are losing money that's supposed to be coming in their pocket, so that's a patrimonial loss. Loss of value to value of a motor vehicle. The fact that your motor vehicle is no longer there, maybe you have to take taxis and it was cheaper to use your motor vehicle. Expense of repairing a motor vehicle. Maybe your motor vehicle was not damaged or beyond control and it was repaired. And at the time that you are repairing your motor vehicle, you lose out on business and you have to also pay the penalty to fix your motor vehicle. You're taking money out of your pocket and you are paying. That is called patrimonial loss. Your non-patrimonial loss will be your pain and suffering, the pain that you felt because of the injuries that you suffered. You can't measure that in economic terms. So that's called your non-patrimonial losses. So you can be covered for both your patrimonial losses, your out-of-pocket losses, or your non-patrimonial losses that cannot be covered or cannot be measured by economic terms. The economic function of insurance, so uncertainty provides risk, therefore they are evaluated with the reference to the probability that an event will occur and the impacts that it does have. So if risk is certain, if the event is certain, then there is no risk. Direct measures can be taken to prevent the materialization of a risk. For example, you want to insure your premises, or you want to secure your premises and ensure that no one comes in, no one that you don't know intrudes on your premises, or you want to maintain your motor vehicle. Maybe during the night, you park your motor vehicle in a locked garage. But sometimes these measures that we try to take are inadequate and we don't have the ability to control the environmental factors that actually can harm us. So in order to manage this risk, the entire risk or part of the risk is then transferred to the other person. So by looking at the law of insurance or insurance as a whole, you are selling your risk to someone else, and someone else is buying the risk that you're going to suffer from you. Okay, so what is insurance? Insurance means the transferring of a risk by means of a contract. You are transferring risk to the insurer. In return, you are paying a premium. The risk is transferred and the contract is, it determines that the insurer will indemnify or otherwise perform a benefit to insure if a risk that is defined in the contract occurs. So in exchange for the transfer of the risk, the insured must pay an amount to the insurer, which is called a premium, and it must be established contractually. So what is the difference between your insurance law and insurance business? So insurance law governs the transfer of risk through insurance, and market forces will place significant constraints on the activities of insurers. So an insurer may be prepared to indemnify an insured even if he could not legally or be compelled to do so, or it would not make business sense. However, market forces sometimes also work against the insured parties. So in circumstances, the protection of the law will be essential to the insured parties, although the law now has been expanded, and it also supports the insurer. Okay, so the market will ultimately determine when and what terms the risk is transferred in terms of the insurance policy. Can I get a thumbs up that you guys are with me with regards to the concepts of insurance up until insurance law, insurance business? Okay. Okay, so if you are looking for insurance laws, like what laws do you have to look at? So you can look at your common law. Your common law is basically legal rules that are taken from other legal systems and are applied here in South Africa and as developed by our courts to suit our laws or our functioning or our environment as South Africans. So most of South African common law is derived from English law, and as law develops, the English common law rules as received from the other legal systems is modified and it replaces more suitable rules for us. However, the courts will depart from your English common law rules only in exceptional cases. So you know that you can find insurance law under common law if you're looking for insurance law in South Africa. And you know that common law is laws borrowed from other legal systems, applied in South Africa, but modified by the courts to suit South Africa's legal system and how South African systems work. We further have statutes. Okay, these are acts of parliament. It's the parliament that make up these laws, or they draw up these laws. What type of statutes do we have? We have the Long-Term Insurance Act. We also have the Short-Term Insurance Act. So these two acts are primarily concerned with the conducting of insurers and in dealing with the insured parties. And it also regulates in some sort of way your intermediaries, such as your insurance brokers. Your Long-Term Insurance Act plus your Short-Term Insurance Act are mostly enacted to replace your common law. Remember, common law are laws that are taken from other legal systems from other countries. Okay, so the statutes tend to replace the common law, that the common law sometimes is too harsh on things. So the legislation tries to balance out the common law where there is conflict. Okay, another type of statute that we can use or refer to in terms of your insurance law is the Insurance Act. Now, this act controls and regulates insurers. It supervises the insurers, and it provides rules to protect the client. Okay, so that is the Insurance Act. We also have the Financial Advisory and Intermediaries Act. Okay, with the Financial Advisory and Intermediaries Act, it regulates the registration and activities of the insurer. So the insurance company needs to regulate or needs to be regulated under the Financial Services or Advisory and Intermediary Services Act, and they actually need to stipulate whilst they're registering what sort of insurance they are going to offer out to people. And then what the Financial Advisory and Intermediary Services then does is that they make sure that that insurer has enough to cover the insured persons should they be a loss or should they suffer a loss in any way. They make sure that enough assets are available in their particular business in order to insure these persons. We also have the Financial Sector Regulation Act, and this act then establishes and determines the structure and powers of the institution that regulates the firms and how they operate. Okay, so there are different types of statutes that are applicable with regards to your insurance law. You can have a look at your subordinate legislation, your hard legislation, and your soft legislation, and your alternative dispute resolution. So if there's a conflict between, you'd find that there could be a conflict within the insurer and the insured and the policy that they entered into. For example, the insurer may refuse a claim that you have filed with them. You can take it to an alternative dispute resolution that deals with insurance, okay, before actually taking it to court. So these are the different sources of South African insurance law. You can have a look at page 345 of your textbook to read more about the sources of South African insurance law. Then we have the 3 branches of insurance law. So we have insurance contract law, we have statutory regulation of insurers, and we have the law of insurance intermediaries. We're going to look at each of the branches in detail. Okay, insurance contract law, it's a contract between the insurer and the insured, and the contracts that these people get into or enter into is called a policy, and it forms the basis of their relationship. So the law determines what will constitute an insurance contract and when it will be concluded and on what terms, how can it be understood, and if a particular situation is covered, then it needs to be paid out according to that policy. So the general principles of contract also applies to insurance contract because it's still a contract, even though it's most of the time it's referred to as a policy. So in the past, you'd find that contract law strongly favored the insurer as opposed to the insured. But now you find that the laws that we have currently balance out the relationship between the insurer and the insured. You find that the insurer has obligations and the insured has obligations as well, as much as both parties have rights to that policy. The regulation of insurers, how are insurers regulated? So the law regulates insurers to reduce the risk that they will re-innate on their properties. So insurers must be registered with the supervisory body, which is called the Financial Services Board, and they must also stipulate what type of insurance they are going to canvass out to people. They must hold assets which allow them to perform their obligations to the insured parties, and they must also report periodically to the Financial Services Board, which regulates them. They must be well managed or comply with the very high standards that are required of insurance companies. The third branch is regulation of intermediaries. So we'd find that most of the time you're not sure whether you're dealing with an insurer or you are dealing with an intermediary. Now, an intermediary is a person that's an in-betweener. For example, an insurance broker. Most of the time people deal with insurance brokers. So the law then saw a gap, okay, that insurance brokers are there in this particular contract, but they are not regulated. Now the law regulates insurance brokers. So you'll find seldomly that you will deal directly with the insurer. You'd find that insured persons usually deal with the broker. So your call center people that call you, they might usually be brokers and not the direct insurer, but sometimes you might deal with the direct insurer. So intermediaries ordinarily intercede between the insurer and the insured, and they facilitate the conclusion of the policies between the two. They also collect and account for premiums on behalf of the insurer, which is something that the insurer should be doing, but we see that intermediaries can be collecting premiums on behalf of the insurer, then in turn paying it to the insurer. So most important types of intermediaries, you have your representative intermediary and you have your independent intermediary. A representative intermediary acts on behalf of certain insurers. So your insurance agents or your canvassing agents will be your representative agents. And your independent intermediaries do not act for a particular insurer. They will be your insurance brokers, for example. So brokers facilitate the conclusion of the contract between the insurer and the insured, and they sometimes perform other intermediary functions for the insured or the insurer, sorry. So brokers should be independent and find insurance in the most favorable terms for the client. So you'd find that they look at a lot of, a broker will look at different insurance companies, okay? And then they will find the best suited for you or the best price for you, because they are independent and they do not act for a particular insurer. They basically seek out insurance that is going to be at the best for a particular client. So brokers should be independent and find insurance at the most favorable term for a client. Brokers often collect insurance premiums on behalf of the insurer, and therefore it is sometimes difficult to distinguish between an insurer and a broker, okay? A broker accordingly may be a public face of the insurer. So where private persons and businesses use brokers to deal with insurers on behalf of brokers, they are required to act with reasonable care and skill. Just like your laws, your statutes requires reasonable care and skill from the insurer, it requires reasonable care and skill from your intermediaries, such as your brokers. So when an insurer refuses an insured's claim in the circumstances where the broker could have prevented the refusal of a claim by taking reasonable steps, the broker can be liable for the insured's loss. So the broker will be liable either in terms of contract between the broker and the insured, or on the basis of delete. So we looked at the case of Lipperman, okay, diamond cutting versus MIB Group. So you'll see that on page 347 of your textbook. So what happened basically here is that Lipperman used a broker to seek out an insurance policy. So this broker sought the best possible insurance policy, and then a policy was entered into between Lipperman Diamonds Cutting and the insurer. So there was theft of diamonds in this business, okay? And a claim was put through because the policy said that Lipperman Diamonds Cutting were covered for theft, okay? Also in the policy, it was said that this particular company must keep detailed records of their transactions, how much they sell, how much stock they have at a particular time. So they should have kept all these important details in their books. When the insurance company came to conduct an inquiry or look at the business premises where the theft occurred, they saw that, or they figured that the books were not in proper shape. So they declined the claim on that regard. So what then Lipperman did is that the Lipperman went against the intermediary, the insurance broker, and said that I am able to sue you in terms of the law because we have a contract that you will seek out the best possible insurance for me, and you will also notify me of the terms of the policy. And when this matter went to court, the court said that there was no duty on the intermediary to spell it out to you that you need to keep proper books. Every functioning business knows for a fact that they should be keeping proper books, okay, and you didn't, and the claim against the broker also failed. But this case symbolizes the fact that you can claim against the insurer, okay, you can file an appeal if your claim is refused, but if there was a broker in between, you can also claim, you have a claim against the broker because the broker was acting independently and there's a contract between the insured person and the broker, just as much as there's a policy between the insurer and the insured person. Okay, can I get a thumbs up that you guys understand this case and regulation of intermediaries? Okay. All right. So in 2022, insurance intermediaries and persons who gave advice on insurance had to be regulated under the Financial Services Advisory and Intermediary Services Act, and a person may only provide advice on a particular product if they are licensed. So we see now that intermediaries need to be registered, and that's only when they are able to give advice, and only only fit and proper persons will have licenses to give advice of that nature. Okay, and the different types of insurances now, we have your interest being protected, the duration of insurance, and the peril or the event insured against. So these are the types of insurance that can be distinguished on different grounds. So firstly, interest being protected. So we have indemnity and non-indemnity insurance. So with indemnity insurance, it is intended to make up for whole or part of the financial loss. And we did cover financial loss. We said that it's patrimonial loss. So your indemnity insurance will cover up your patrimonial loss, and usually you'll get indemnity insurance cover over your assets. So maybe it's your furniture, your household assets, okay? It could be your cell phone, it could be your house, okay? So it's anything that we can measure economically, or where if we suffer a loss, that economic loss can be measured, okay? The amount can be measured. So the value of the indemnity will be determined with reference to the actual financial loss caused by the insured, okay, by the insured event. Then a common form of indemnity insurance will be your property insurance. Like I said, you will insure your house, your assets, your most valuable assets. Maybe if you have a diamond or gold, you will insure it against theft. So it may be for the reduction in value or a positive element of the property. So it could be that your property is damaged, your property is destroyed, okay? Or it can be corporeal things such as your vehicle, your ship, something that you can touch, tangible things, or incorporeal things, claims like money claims against other persons. You can also insure against that. That will fall under indemnity insurance, okay? Your non-indemnity insurance, okay, sometimes called your capital insurance, is not aimed at indemnifying the insured for economic loss. So this loss that you will be covered for here will not be able to be measured economically. It simply involves the payment of a specific amount on the happening of an insured event. The amount of the insurance is determined when the policy is taken out with reference to the happening of the insured event. So losses covered under your non-indemnity insurance, for example, will be your life insurance. Right now, I don't know how much my life is worth. Okay, so I cannot calculate or cannot be certain as to how much a person's life is worth. So your non-indemnity insurance, your pain and suffering, things that you cannot measure up economically. Then we get to the duration. So the distinction between your short-term insurance and your long-term insurance. It is important to know the difference between these two types of legislation. Remember, we said that we have the Short-Term Insurance Act and the Long-Term Insurance Act. So the Short-Term Insurance Act is related to indemnity, and the Long-Term Insurance Act is related to your non-indemnity. With your Short-Term Insurance Act, it equates to, for example, you getting covered to indemnify you from a loss or suffering a loss or damage. Maybe if you lose maybe your cell phone from theft, okay? That's short-term insurance, okay? Your long-term insurance acts maybe losing someone's life, okay? So your long-term policies, okay, these policies will not necessarily endure for a long time, but usually persist for a longer time than your short-term insurance policies. So what is a peril or an event insured against? So the insurance cover is frequently defined with reference to a peril or an event which will cause the harm central to determining the risk insured against. The harm caused will be from fire, for example, from death, from theft, from political instability. These will all be covered under your insurance policy. Do you guys now have an idea when we talk about insurance, when we talk about non-indemnity insurance, indemnity insurance, your short-term insurance, long-term insurance, and the fact that indemnity insurance will include your patrimonial losses and your long-term insurance will include your non-indemnity insurance, which is your non-patrimonial insurance. Do you guys understand? Are there any questions? Any questions? Okay, let's look at what part 2 requires that you look up in your textbook as well. So part 2 deals with the essentials of a contract or of an insurance contract. Okay. It also deals with the insurance contracts distinguished from other contracts. So just how we distinguished a contract of sale from other contracts, we will distinguish a contract of insurance from other contracts. So what are the essential terms that need to be there in a contract of insurance? So there are certain legal rules which apply only to insurance contracts. So the insurer and the insured must agree on the terms which are essential before the agreement will be an insurance contract. So these are the 4 terms that you need to know. You need to know that firstly, in an insurance contract, all these 4 terms must be present. Firstly, the insurer must undertake to pay a sum of money or perform some other benefit. Okay. Secondly, in exchange for an undertaking, the insured person must now pay a premium. Okay. Thirdly, on the happening of an uncertain or unplanned event. And fourthly, which performance will indemnify the insured in the case of indemnity insurance or make up for the materialization of the risk in accordance or in the case of non-indemnity insurance. So all of these essential terms must be present for a contract to be now a specific contract and specifically an insurance contract. So we're going to go into detail with each of these essential terms, okay? So the fact that the insurer undertakes to pay or perform something, okay? So the insurer will normally undertake to pay the insured money on the materialization of a risk. So you'd find that maybe if you have damaged your car, your insurer might pay you out, okay? Might say, okay, here's an amount of 15,000 rands to fix your car, okay? So where the insured is indemnified for a loss caused to something which will have to be replaced or repaired within the discretion of the insured to decide whether he uses the money for repairing the motor vehicle or uses the money for something else, okay? The insurer will sometimes undertake to compensate the insured, which is more directly, which is to repair or to replace. So the reinstatement clause allows the insurer to determine if he wants to compensate the insured directly or indirectly. So there's a clause called the reinstatement clause, which stipulates that in this particular circumstances, we will insure you directly. For this particular circumstance, we will insure you indirectly, and that clause is called the reinstatement clause. So when an insured makes it impossible for the insurer to choose to repay the object of risk, the insurer is allowed to firstly pay as compensation only the amount of money which it would have cost to perform the repairs if it had been given the opportunity to do so. So if you damage your motor vehicle by accident and you go and repair it and then you claim from the insurance company, then they may choose to compensate you for only the cost that it would have amounted to them for repairing. Maybe you were charged by a panel beater 15,000 rands and they would have spent only 8,000 rands fixing this particular damage. They will only pay you that 8,000 rands because they weren't given an opportunity to firstly look at the car. Secondly, replace the thing in exchange for taking over the repaired thing, or they may just take the car if it's overly damaged and replace it with a new car. And thirdly, pay the replacement value for the repaired thing in exchange for taking over the repaired thing. They may take away your car and pay off your debt from that you still owe if your car is financed. So the insurer then has these options when they are looking to pay you out. In exchange for the undertaking, Okay, the insured must now pay a premium. That is the second element that must be present in an insurance contract. So the premium does not have to be paid before an insurance contract comes into being, but the insured must have at least made an undertaking to pay, or the performance of the insurer must be made subject to the payment. So you'd get that you enter into an insurance policy, maybe a life insurance policy, and they say that as soon as you sign up for the policy, as soon as you enter into the policy, you are covered. Okay, so even before you pay your monthly premium at the end of the month, you are covered. So you have made that undertaking to pay. It does not necessarily mean that you should have paid, but you made an undertaking to pay by signing that contract, you would be covered for some insurance policies. So therefore, a contract will be an insurance contract where it will expire if the premiums are not paid at a certain time, or will not come into effect or continue unless the premiums are paid. There you have to look at the case of Constantia Insurance versus CompuSource, and this is with regards to an insurance contract where the premium was payable on a no-win, no-premium basis, and it was not considered a contract. So CompuSource in this case was involved in a dispute with another firm. The dispute was referred to an arbitrator, and then Constantia then agreed to indemnify CompuSource for the legal costs that Constantia would incur if the arbitrator decided in the favor of CompuSource opponent. So the premium was payable on a no-win, no-premium basis, and if the risk materialized, then no premium was payable. Then the court did not have to decide the matter, but it can be argued that it cannot be an insurance contract in this particular point in time. So you can have a look at page 351 of your textbook to see the case of Constantia Insurance versus CompuSource. Still with the exchange for an undertaking to pay a premium, so insurance policy may stipulate a date on which a premium might be paid. So your Long-Term Insurance Act determines the liability of the insurer, or the liability that the insurer will be suspended until the first payment is paid or arrangement is made to pay that premium. However, a late payment will often not have effect to a policy, but your long-term and short-term insurance policies often allow for a grace period of 15 days. So if your date of paying your premium was the 15th, a grace period would be allowed, a grace period of 15 days would be allowed to say that you will still be covered for the 15 days, but failing which on the 16th days, if you don't, on the 16th day, if you don't pay your premium, then the insurance policy will then lapse. Your Long-Term Insurance Act also seeks to secure the benefit already earned when the insured seeks to pay the premium. So it seems that an insured premium should be paid in money and not in kind, okay? No other ways, but there are exceptional circumstances. So in both long-term and short-term insurance policies, payment to the intermediary will be deemed as payment to the insurer. So if you do pay, or if you are involved with a broker and you pay the broker, it means that you have paid the insurer, because the broker, remember, is an in-betweener. The third element on the happening of an uncertain event. So indemnification must be subject to the happening of an uncertain event. An event will be uncertain if the parties to the contract do not know if it will occur or when it will occur. And a good example here is to use death. Okay, we know for sure that death will happen. So it's a certain event. But where the uncertainty comes in is when we don't know when a person is going to die. So that's why life insurance can be taken out, because there's uncertainty, but not on the date itself, but on when it will happen. The agreement will be an insurance contract only if the parties to the contract are uncertain about the occurrence of the event. Okay, and lastly, your fourth requirement to indemnify the insured which means to that's indemnity, to provide indemnity insurance, or otherwise make up for the materialization of the risk with your non-indemnity insurance. So the performance of the insurer must meet certain legal requirements, and these legal requirements differ from your indemnity insurance and your non-indemnity insurance. Now you know that with your indemnity insurance, you are taking out your short-term insurance, and that is governed by the Short-Term Insurance Act, and we are indemnifying our assets that we can, where if a loss occurs, we can measure it, we can measure our economic loss, okay? We can calculate what the losses are, basically. With your non-indemnity, you're taking out your long-term insurance. With your long-term insurance, it is governed by the Long-Term Insurance Act, and it is where the loss that will be suffered cannot be calculated, it cannot be computed, with your economic loss cannot be properly calculated, right? So the prerequisite of non-indemnity insurance is that the insurer must agree to pay the insured a sum of money to make up for the materialization of the risk. Okay, also with regards to indemnifying the insured or otherwise making up for the materialization of the risk, some may argue that this requirement entails that the insurer must agree to perform on the happening of an event in which the insured has an insurable interest. So an insured has an interest in the happening of an event, and if the happening of the event will cause economic harm, or if the law provides that such an interest exists. However, this approach is gradually falling out of favor as insurable interest now plays a more restrictive role in your insurance law. So the question of insurable interest will be relevant when determining whether there was compliance with the requirements and that the insurer must undertake to indemnify a loss or make up for the materialization of a risk. Here, the insurable interest will be evidential, by showing that the insurer had the intention to indemnify the supposed insured. Okay. And then for your second part of part 2, you need to look at your insurance contract, okay, as opposed to other contracts such as your gambling or wagering or gambling contracts, okay? So what is the difference between a gambling contract and an insurance contract? What is the difference between your manufacturers, sellers, and extended warranties as opposed to your insurance contract? What is the difference between your surety and your insurance contract? Okay, there are slides with voice notes that you can listen to, and you can also read page 352 of your textbook to 354 of your textbook and know how to distinguish between an insurance contract and your gambling contracts, an insurance contract, and your manufacturers, sellers, and extended warranty contract, your insurance contract, and your suretyship contract. Okay, that will be your reading and your summarizing of the textbook. All right, can I get a thumbs up that you guys are still with me? Okay, let's look at part 3. So I know that we're going to run out of time soon. I'm not sure if we're going to be able to cover part 3. So we're just going to go over the topics that part 3 covers. And there are slides with voice notes that you can listen to at your own time. So with part 3, we talk about the formation of an insurance contract. And this is all under chapter 8. So the formation of an insurance contract, your proposal terms, how is insurance proposed, the conclusion of insurance policy by direct marketing. So if you have been with someone who signed up for an insurance policy, you would have noticed that they were on the phone for a long period of time and they were being asked questions and they were answering questions. And that's your conclusion of an insurance policy by direct marketing. So usually now you'd hardly find people walk into the insurer and asking the insurer to insure them, but the brokers and your representative intermediaries will then call a person and then persuade them to enter into an insurance policy. And then a whole lot of questions are given to them and they answer these questions. And at the end, a long list of terms of the contracts are read out, and these calls are recorded, and then a policy is sent to the person who has joined, who is the insured now. Okay, so the conclusion of policies by direct marketing, that chapter, that particular section deals with how an insurance policy is concluded. Then you have your cooling off periods. So after you have agreed with on the phone into entering an insurance contract, can you cancel that contract maybe even before your first premium? Okay, you have a certain number of days for your short-term insurance and your long-term insurance to cancel, okay, at no charge. So people do have or are offered a cooling off period. So say, for example, I am called by your ABC insurance and I enter into an insurance policy with them, and they are meant to deduct at the end of the month on the 30th for my first premium, and they charge me for my household content, they charge me 1,800 rand, okay? And the following day, someone else calls me from another insurance company and they're going to charge me 1,500 rands. Now I see that I'm going to be making a saving. So I enter into a policy with them. And then because I'm still within the cooling off period for my short-term insurance, I call the first person, the first insurer that called me, and I concluded a contract with them. I call them to cancel because I'm within the cooling off period. So it will be at no charge to me if it's within the cooling off period. The cooling off period is basically time when the person who entered into a contract can actually decide that actually they don't need to enter into that contract and they want to cancel it. And that cooling off period is stipulated by the law. So it's reasonable to cancel within those amount of days. So look at the cooling period for your short-term insurance, look at the cooling off period for your long-term insurance. Then part 3 as well also elaborates on insurance policies and policy documents, the documents that are now sent over to the insured person. We also speak about legality. So what happens where a term or a clause in the insurance contract is not legal? Can we scrap out the entire contract? Can we scrap out the entire insurance contract? Or is it just that particular term that is wiped out and the entire contract comes into being? Okay, so we look at legality in that way, and we look at disclosures by the insured. So we know that the law now wants the insured person to disclose certain information, even if it is not asked by the insurer. So when you are entering into a policy, you'd find that a long list of questions are asked and you need to answer them, okay? And you need to answer them truthfully and you need to be honest when you're answering those questions. But should a question not be asked, but for example, it's about your motor vehicle and you have entered into several motor vehicle accidents and maybe one was a minor dent, maybe someone dented your car at a parking lot. And if they didn't ask you about that, or they didn't ask you a question that led you to talk about that minor dent, you need to disclose it to the insurer because the law now requires the insured to disclose information. Disclosures by the insurer and the intermediaries, okay? The law also requires that the insurer or the intermediaries, if you're dealing with a broker or a representative intermediary, they need to disclose certain information. For example, they're covering you for fire that is caused maybe by electricity wiring in your house only, not fire that is caused by something else. If that's the case, they need to disclose to you that we only cover you for fire, but fire that is only caused by electricity faults. Okay, so disclosures by the insured, disclosures by the insurer. Okay, have a look and also listen to the recordings. and supplement your slides with the textbook, okay? And then your part 4, in your part 4, basically, we talk about insurance claims. So what are insurance claims? How do you bring about an insurance claim? What is insurable interest? We've touched on this in part 2, okay? Insurable interest in indemnity insurance. With indemnity insurance, you know that you're talking about your short-term insurance and you are now covering yourself up for the loss or harm caused to property that can be evaluated economically, all right? Insurable interest with regard to non-indemnity insurance, for example, your life insurance, non-patrimonial losses, okay? Then the manner in which claims may be brought. So within what period can your claim be brought? Is it within 24 hours, 48 hours? It will depend on your policy that you sign with each of the insurers that are covering up for different sorts of harm that you may suffer. Okay, so look at the manner in which you can bring an insurance claim, and there's a case there on how much time you're given to bring an insurance claim. The most important cases there are your cases of Napier, okay, Napier, and your Barkhazen case. They appear on page 365 of your textbook, but if you listen to the recording, the summary of the cases are discussed there, okay? Then we talk about your subrogation, cession, and contribution. So what is subrogation? What is cession? What is contribution? So you'd find that sometimes you will enter into a motor vehicle accident, for example, and it was not your fault. Okay, maybe it was a fault of a third party, another driver. Okay, so what the insurance will do, the insurance company will fix your car and then sue using your name and sue the third party in order for them to recover what they have paid out to you. So that is what subrogation, your cession, and contribution talks about. Okay, and that will then bring us to the end of the law of insurance. Are there any questions? Are there any questions so far? Any questions, guys? Okay, if there are no questions, I will see you next. Do I see you guys next week, or is it that week? All right, thank you so much. Enjoy the rest of your day and enjoy the rest of the week.